if you're going to present these projections. But I think in lost profits cases, from an expert witness perspective, the projections are everything. The projections are the basis. So you typically interview the person that created the projections or the owners and say, how are you going to get there? Does it make sense? We had this in a case where the guy said he was going to have a profit of 50% net profit margin. And I was like, well, so there's just not a lot of companies that make 50% to the bottom line. So tell me how you're going to get it done. And he didn't have a good, plausible reason. So foundationally, now you're relying upon documents that are not going to withhold logic in the courtroom. To me, that's too wobbly of a foundation to set your entire opinion upon.
Well, and that's where this case gets interesting. The appellate court decision, my first read through, I could tell, even without seeing the words that appear later, that the appellate court didn't agree with the plaintiff's expert. But the standard on appeal was abuse of discretion. And they come right out later and say, even though we may not agree with how the trial court allowed this to come in, it was not an abuse of discretion and we won't disturb it. So that's one piece of it. The other thing is the person who created the projections was actually somewhat of a favorable witness for the defendant. Either he knew him personally, we don't know from the appellate decision. And another piece of evidence in this case was omitted, was excluded because of a decision by the defendant's lawyers. And that was the actual performance of the acquisition. And those were 3 years of tax returns. Discovery had closed 2 years earlier. And at the time of the close of discovery, because this is a 6-year litigation, so there was a big gap between discovery ending and the trial. The tax returns were not available. Now the acquisition company is a third party. It's not a defendant. It's not a plaintiff. It's just a third party, but they control the tax returns. When the defense counsel finally submitted to the plaintiff these tax returns, they showed 26 cents on the dollar of the projections. So the projections, which originated in 2020 from the acquired company itself, were off by 74%. 74% overstatement. The defense used that person, the executive vice president of the Norwegian parking technology company that owned the acquisition target, to testify that he prepared the projections. He was personally aware of the business records in the tax returns and that they fell short. They were only 26 cents on the dollar, 74% lower in actual performance. But the defense lawyers made a very ultimately negative decision for their own client. So maybe there's an argument that it was a strategic choice. Normally when evidence is delayed or excluded, or there's a fight over hoping to exclude something, it's because the evidence hurts your side. This was evidence that would massively help the defense. It didn't exist when discovery closed. Everybody agrees with that. But if Federal Rules of Civil Procedure 26E have an updating obligation, if even after the close of discovery, new or contradictory evidence, you become aware of it or it's in your possession. It's not simply in your possession. It's, are you aware of it? You have an obligation to timely update the other side. This is not trial by surprise. Well, in the actual facts, the defense lawyers submitted the tax returns that would massively help their case a week before trial. 1 week before trial. And under Federal Rules of Civil Procedure 37, they were excluded by the trial court as a sanction for delaying the production of the tax returns, which left the defense with only a person, this third-party witness, who's the executive vice president of the Norwegian-owned parking technology company that owned the acquisition target at the time. And he knew that he wrote the projections that were wildly overstated. He knew that the actual performance was 74% lower. And all the defense had at trial was his testimony.